My name is Cameron Sim. I'm International Counsel at Debevoise and Plimpton, based in our Hong Kong office. And it's my pleasure to bring you some insights from Hong Kong for New York Arbitration Week 2022. To tie into this year's theme, International Arbitration, Who is in Charge? I'll be giving a brief overview on recent developments on obtaining interim measures from mainland Chinese courts in support of Hong Kong-seated arbitration. Although when it comes to interim measures, perhaps it's less a question of who is in charge as to who can assist and how. Who can assist a party to vindicate its rights pending their ultimate determination by the arbitral tribunal? Well, with one exception, as I will explain today, mainland Chinese courts cannot assist, and they are not empowered to grant interim measures in support of foreign-seated arbitrations, although there are some exceptions in the field of maritime arbitrations. So to take an example, a party to an arbitration seated in New York will not be able to obtain interim measures from a mainland Chinese court in support of its substantive claims being pursued before a New York-seated arbitral tribunal. And actually, until recently, this was also the case for Hong Kong. So despite Hong Kong being a special administrative region of the People's Republic of China, historically, parties to Hong Kong-seated arbitrations also could not obtain interim measures from mainland Chinese courts. But recently, this has all changed, and it's changed by virtue of what is known as the Interim Measures Arrangement, which is truly unique to Hong Kong. This is a fairly new arrangement, having come into force around 3 years ago. And this arrangement offers parties to China-related transactions a new arbitration option. So they can enjoy the benefits of arbitrating in Hong Kong, whilst also being able to apply for interim measures from mainland Chinese courts in support of their Hong Kong arbitrations. Hong Kong is the first and remains the only jurisdiction to have such an arrangement with mainland China. Now, it's not all parties to Hong Kong arbitrations that can benefit from these arrangements. The arbitration must be administered by what is known as a qualified arbitral institute, of which there are 6. And importantly, these include the ICC, the HKIC, and CTAC, which are the 3 most popular institutes for Hong Kong-seated arbitrations. What interim measures are available under the arrangement? Well, they are classified in accordance with PRC law, and they broadly fall into 3 categories: property preservation, evidence preservation, and conduct preservation. And the latter is a form of relief which compels or prohibits parties from taking certain actions. It's mostly limited under PRC law to IP cases. As compared to under Hong Kong law, and indeed most common law jurisdictions, there's a slightly lower threshold to obtain interim relief under PRC law. So an applicant generally only needs to show that it faces a substantial threat of irreparable damage if the interim measure is not granted. If that can be shown, then ordinarily the interim measure will follow. Whereas under Hong Kong law, and in most common law jurisdictions, an applicant would need to satisfy a higher threshold, and established in addition that first, there's a serious question to be tried, and second, that the balance of convenience lies in favour of granting the relief. We've seen mainland courts acting reasonably quickly on applications under the arrangement. Currently, it's around a 2-week processing time from receipt of the application to a decision being made. And we've definitely seen parties enthusiastically embracing this arrangement. In the first 3 years of its operation, there have been over 60 applications made across the various arbitral institutes, and assets amounting to over USD 3 billion in value have been preserved by the mainland Chinese courts. Perhaps most strikingly, there has been a very high success rate of applications under the interim measures arrangement. Currently, the success rate is hovering around 90%, which is extraordinarily high. We've also seen the arrangement heavily utilized by international parties, and to date, around 3/4 of applications have been made by parties based outside mainland China. So to bring this back to the theme, when it comes to interim measures from mainland Chinese courts in support of Hong Kong-seated arbitrations, is it the courts or is it the arbitral tribunals that are in charge? Well, I would venture that, as with everything in arbitration, it is the parties who are in charge and whose autonomy is protected by giving them the option to seek interim measures from the arbitral tribunal or from a mainland Chinese court. So with that, I wish you all the very best for New York Arbitration Week, and I will hope to welcome you in Hong Kong soon.